好，各位同事，就我哋呢
Members, welcome to the first meeting of the Bills Committee on Companies Amendment Bill 2018. It's time and we have a quorum. First of all, we will proceed to election of chairman. Nominations, Mr. Ronnie Chan, you nominate Mr. Christopher Chung. Any seconders? All right, Mr. Wong Ting Kwong. Mr. Christopher Chung, do you accept the nomination? Yes. Any further nominations? To the count of 5. 1, 2, 3, 4, 5. We only have a single nomination, so Mr. Christopher Chung is elected chairman. Members, I'd like to thank you for all your support. It's time and we have a quorum, so let's get started with the meeting. Do members feel it's necessary to elect a deputy chairman? No. Yesterday, Dr. Junius Ho indicated that he would like to join the Bills Committee, but since the deadline has lapsed, Dr. Ho's letter has been tabled. So any objections from members towards this late addition? If not, we would welcome Dr. Ho to the meeting. Any objections? All right, so we would welcome Dr. Junius Ho to the Bills Committee. This is the first meeting of the Bills Committee, so we would first invite the administration in.
佢哋嗰啲人名咧。今日係我哋嗰個公司修訂條例草案嘅第一日。
This is the first meeting of the Bills Committee on Companies Amendment Bill 2018. I'd like to introduce the public officers. First of all, Ms. Whitney Ng, Deputy Secretary for Financial Services and the Treasury. Mr. Te Chi Wang, Principal Assistant Secretary for Financial Services and the Treasury. Ms. Ada Chong, Registrar of Companies. Mr. Jonathan Look, Senior Government Counsel from the Department of Justice. Mr. Alan Chong, Senior Government Counsel of the DOJ. Ms. Jeannie Fong, Assistant Secretary for Financial Services and the Treasury. Mrs. Karen Ho Lau Ka Kam, Consultant Company Law of the Company's Registrar, and Ms. Ellen Chan, Deputy Principal Solicitor of the Company's Registry. Deputy Secretary, can you brief us on the bill? First of all, I'd like to thank members for participating in the scrutiny of the Companies Amendment Bill 2018. The bill received its first reading in April this year at LegCo, and the second reading debate has also started. We would first like to brief members on the content of the bill. As members might know, In 2006, the government triggered a comprehensive review of the former company's ordinance. It lasted 6 years and was completed in 2013. The new company's ordinance commenced operation in March 2014, and its operation has been smooth. The new CO provides a modern statutory framework for incorporation and operation of companies in Hong Kong, and it achieves the policy objectives of enhancing corporate governance, ensuring better regulation, facilitating business, and modernizing the law. After the commencement of the bill, we have monitoring its operation, and we have collected feedbacks from stakeholders. After a thorough review, we felt that certain provisions can be amended to improve clarity and operation of the new CO and further facilitate business making in Hong Kong. The proposed amendments are included in the company's Amendment Bill 2018. As I said, the new CO has been implemented smoothly since its commencement in 2014. So our proposed amendments are technical in nature. The bill carries 115 legislative amendments, and we have broken them down into two main categories. The first group are amendments to incorporate new developments after the commencement of the new CO, while the second group are amendments to clarify policy intent or remove ambiguities and inconsistencies. We would brief members on the key amendments under the two groups. For the first group, amendments to incorporate new developments in recent years. And there are two types. The first type, simplified financial reporting and the relevant provisions, and the second type, updating the accounting-related provisions in Part 9 and Schedule 1 to the new CO. As for expanding the scope for simplified reporting, it serves to facilitate SMEs. Holding companies of an eligible group of companies which meets specified size criteria can prepare simplified financial statements and is subject to less stringent requirements for preparation of auditors' reports and directors' reports. The relevant criteria are stipulated in the CO. SMEs that are eligible with business size of less than $100 million and within 100 employees would be eligible. When submitting auditors' reports, less stringent criteria would be applied, and certain exemptions can be granted for directors' reports. For instance, business review does not have to be included in the reports. In order to provide more flexibility to SMEs to reduce compliance costs, we propose to allow or to expand the scope of exemption so that holding companies of two other types of corporate groups can benefit from the simplified reporting requirement. However, we require both the holding company and all its subsidiaries to meet the size criteria. In other words, our exemption would only apply to SMEs. For the first group of amendments, they apply to mixed groups. Right now, only corporate groups comprising private companies or guarantee companies can enjoy exemption. Once different companies exist within the same group, there would be no exemption. So we propose to exempt corporate groups comprising both private companies and guarantee companies. The second group of exempted companies would cover holding companies of groups of small private companies and guarantee companies, or mixed groups with non-Hong Kong subsidiaries. We suggest that holding companies of groups or mixed groups with non-Hong Kong subsidiaries can also enjoy the exemption. I would now brief members on the second type of amendments, and that is updating the accounting-related provisions in Part 9 of and Schedule 1 to the new CO. Since the new CO commenced, the relevant accounting standards have been updated, so we are making relevant amendments to avoid inconsistencies between the new CO and the latest accounting standards. We propose updating the definitions of holding company and parent undertaking in order to reflect the latest accounting standards. In other words, we would establish control as the basis for determining whether an entity is a subsidiary of the parent undertaking and define the principle of control. The second type of key amendments are amendments to clarify policy intent or remove ambiguities and inconsistencies. And three areas are covered. First, display of company name for non-Hong Kong companies. Number two, alignment of penalty provisions relating to financial statements and reports. And number three, streamlining and clarifying provisions to facilitate compliance. On the display of company name for non-Hong Kong companies, we propose empowering the Financial Secretary to make regulations to provide for the requirements on the display of company names and the disclosure of liability status of non-Hong Kong companies. The existing legislation and its subsidiary legislation have or carry detailed requirements on the display of company names and disclosure of liability status. Companies are required to display their names in a conspicuous place, and electronic equipment can be used to display company names. However, the current legislation does not carry the requirements likewise on non-Hong Kong companies. So we propose to align the obligations of non-Hong Kong companies with those of local companies in the display of company names. As for the alignment of penalty provisions relating to financial statements and reports, at present, the penalty level for an offense relating to the revision of financial statements and reports is lower than a penalty for a corresponding offense relating to the original financial statements and report. Therefore, we propose to align the penalty levels for relevant offenses. And in 2013, when LegCo scrutinized the relevant subsidiary legislation based on the calls of the Bills Committee at that time, the government proposed that in the next round of review of the CO, the inconsistencies would be removed and penalty levels aligned. I will now hand over to Mr. Te to continue. In terms of streamlining and clarifying provisions to facilitate compliance, we have the following amendments. First of all, to provide an option for a holding company which is also a wholly owned subsidiary to prepare consolidated financial statements. As for the requirement for a holding company to list the names of the directors of its subsidiaries in the director's report, to provide an option for a holding company to provide such information on its website, or by keeping such a list at its registered office and making it available for inspection. For a group of eligible private companies, the adoption of simplified reporting should require a resolution by members of the holding company only. So the consent of members of all unclassified small private companies would not be needed. As for the company articles, we propose to allow a company's articles to be in electronic form, and if a company has both an English and Chinese name, both names must be stated in the articles. We propose to provide for an exemption from general registration requirement for alteration of articles if such alteration is in respect of a change of company name. And we also propose to allow a company with both an English and Chinese name to display either its English name and a Chinese name. And a company would only need to display either its English name or Chinese name. With regards to the statement of capital, we propose to clarify that the statement of capital should report the capital position immediately after the relevant change, and instead of the change of the material day. And the obligation to give particulars of class rights in the statement of capital only arises if there are different classes of shares. If all holders of shares or members in the class agree to a variation of the class rights, the variation will have effect as agreed.
As for small payments exceptions to the restrictions on payments for loss of office as director, we'll make clear that what will be included and what will not be included. We also propose to make it clear that the court-free procedure for horizontal amalgamation is also available to subsidiaries of a holding company incorporated outside Hong Kong, so long as the merging companies are Hong Kong companies. As for keeping of records, and we propose to make the following three amendments. First, the company record keeping and company administration and procedure, including matters relating to keeping of records of directors, to include resolutions passed by directors without the meeting. Second, granting applications for administrative restoration of companies and expressly provide for government's power to dispose of any property or right vested as a bona vacantia under the predecessor company's ordinance. This is to reflect the actual situation. This is in line with Part 15. And finally, there are many textual and technical amendments to ensure consistency in terminology used by different provisions of the new company ordinance. For example, general meeting should be 成員大會 instead of 周年大會 in Chinese. And having considered the views of relevant parties, we propose Roman script replaced by Latin alphabet. Chairman. Now, in our briefing, we want to say that the Electrical Panel on Financial Affairs supported the proposal at its meeting in January 2018 after discussion. And furthermore, we have consulted relevant stakeholders in 2016, including professional bodies and chambers of commerce, and also the Standing Committee on Company Law Reform, and they generally support our proposals. Chairman, that's our briefing. We'd like to take questions. Thank you. With regard to the amendment bill, do members want to ask questions? Please raise their hands. Mr. Kenneth Leung. Mr. Wang Ting Kwong, did you raise your hand? No. First, Mr. Kenneth Leung. Thank you, Chairman. I have a question on the PowerPoint. Well, there is no page number on the PowerPoint. I think it's page 17, lower part. Amendment to incorporate new developments concerning the two mixed groups and also non-Hong Kong subsidiaries. With regard to non-Hong Kong subsidiaries, do you have a limit on asset size and turnover? It may be a small Hong Kong private company owning a very big overseas subsidiary. Is it eligible then? Yes, the Deputy Permanent Secretary. Thank you, Mr. Leung, for your question. The answer is positive. In our explanation, the exemption should benefit SMEs. Even if we expand the scope for simplified reporting, they must comply with the specified size criteria. To put it simply, as said in one of the PowerPoint slides, one scale requirement is that the annual turnover of the company or total assets not exceeding $100 million and number of employees not exceeding 100. These size-specific requirements will apply to non-Hong Kong subsidiaries. As for the group and also subsidiaries under the group, whether they are Hong Kong companies or non-Hong Kong companies, they have to comply with the size requirements. A follow-up, Mr. Chairman. Can we be reminded of the following? Now, we've forgotten the definition of company ordinance. The small companies, small private companies and eligible private companies, are there any differences in terms of size? In fact, Mr. Leung is very familiar with the law. Under existing ordinance, there are different definitions. Small private companies refer to those that comply with the size criteria, the annual turnover or assets not exceeding 100 million, employee not exceeding 100. And there are also eligible private companies. And the size requirement is higher. Annual turnover no more than 200 million and employee no more than 100. Annual turnover and capital no more than 200 million. Whether they can adopt simplified reporting, if you are an eligible private company, you are a bigger company, you have to comply with an additional requirement, and that is you have to obtain 75% of members who are eligible to vote have to give consent. If it is for the small private companies, there is no such requirement. It will automatically become eligible in respect of simplified reporting. Thank you. And finally, do you touch on annual audit requirement? You require auditing for all companies of different sizes. Is it the case? Thank you, Chairman. Thank you, Mr. Leung. As we have said, these are technical amendments. As for accounting provisions, a major amendment is on defining whether a company is a parent undertaking or a subsidiary undertaking. It's about control. We'll make some amendments in respect of control to reflect existing auditing and accounting standards. As for the other amendments, they comply with the existing ordinance. Next, Mr. Felix Chung. Thank you, Chairman. Now, concerning the company amendments bill, I believe that after the amendment, it will be helpful and beneficial to some of the SMEs. But it is too technical. And if you just look at it, you may not understand. So if time permits, I hope that more time can be given to the technical issues. It's hope that the amendments will give more flexibility to the SMEs and reduce the cost of compliance. In this regard, what are the flexibility and cost reductions? The administration. Thank you, Chairman, and thank you, Mr. Chung, for the question. Mr. Chung is right. The series of amendments are technical. They do not change the policy intent of the existing ordinance. It only clarifies the policy intent and assists the companies in complying with the law. In the coming meetings of the Bills Committee, we are happy to explain the clauses. There are 115 clauses altogether in the amendment bill. Some are rather piecemeal, but some rather systematic. So when we come to each clause, we'll explain to you the background and also the reasons for the proposed amendments and also the views of the trade. So we are happy to explain to you the details. This is the first meeting, therefore we have adopted a rather simplified approach in organizing the presentation and explanation, and some of the details are rather technical. Yes, there will be further explanations. Next, Mr. Chen Chen-ying. Thank you, Chairman. As said by some members, there is quite a lot of paper given to us, and I appreciate the PowerPoint presentation. I have two minor questions and also the question of principle. The first is with regard to 5F of the paper, or point 7, and that is payment or exemption given to a small payments exception to restrictions on payments for loss of office as director. What is the benefit? What is the purpose of that? The Permanent Secretary. I thank Mr. Chen for the question. As for small payment exception, let me explain. Let me put it this way first. The amendment is not to change any existing policy or arrangement. It is only to clarify the policy intent. In the past few years, we've heard some comments that the provisions were rather ambiguous in this regard. According to existing provisions, if a director has lost his office, then other members of the company cannot make payment to the director unless it has been given approval by all the members of the company. There are also other provisions in which said that if the amount is less than $100,000, then there was no need to seek approval of members. How do we count the $100,000? According to provision, when it is a group, there are subsidiary undertakings, and there is a parent undertaking who pays the $100,000, and how should it be calculated? It's not clear, and therefore we clarified the calculation of the $100,000. So if a single company pays the amount, and it will not be aggregated, does it mean that it is an amount paid by a single company within and to the extent no more than $100,000? Well, we will clarify this. You will explain this in clause-by-clause study. Yes, indeed. Concerning G, page 18 of the PowerPoint, concerning record keeping by companies, there are different provisions. What's the purpose?
唔該。
好，多謝主席。
Deputy Secretary. The relevant amendments are scattered among the 115 amendments, so for the details, we will cover it in the clause-by-clause examination. In terms of the record-keeping requirements, they have to do with some meeting records, and we are dealing with resolutions passed without a meeting. The current legislation is not very clear, so our intention is to clarify our policy intent. Sometimes companies might amend the place of registration, and as such, the record-keeping location would also be updated. Under the existing legislation, both updates must be reported to the company's registry. But we feel that if only the address is updated, they would only have to declare it once to the registrar of companies. So this amendment is rather technical in nature. I have some questions about the principles, and on page 5, paragraph 12, the Chinese rendition of render should be 太款人 instead of 借款人, while general meeting should be rendered as 成員大會 instead of 周年大會 in Chinese. These are apparently these are rather basic errors, but very often we would look at both the Chinese and English, while some members would only look at the English but not the Chinese. So for translations done by the government in the future, how can you ensure these basic errors would not be repeated? Thank you very much for the reminder. I would describe these occurrences as typos. The review exercise of the company's ordinance was an extended exercise. I'm not saying it was an excuse. But I can only say that for the future drafting and scrutiny of bills, we would try to be as meticulous with the words as possible, even though we cannot make 100% guarantees. Second round, Mr. Kenneth Leung. Thank you, Chairman. I'd like to ask about slide 17. Under B3, you mentioned court-free procedure for horizontal amalgamation. And in the review of the company's ordinance, many companies wondered how the mechanism for mergers can better facilitate merging exercises. Right now, it only applies to the merger of two Hong Kong companies that belong to the same group. In your review, why didn't you consider expanding the scope of mergers to different companies? Some such merger mechanism might be preferred in certain merging exercises, but you do not allow mergers of these companies. This would affect the flexibility of some companies in planning merger exercises. In the past, different professional groups and companies have raised this question to the government. We did see mergers between Hong Kong and non-Hong Kong companies, and we worked on a number of bills on merger ordinances. So I wonder why you did not include this in your review exercise. Deputy Secretary, thank you very much. As Mr. Leung said, this amendment has to do with mergers for horizontal amalgamation between wholly owned subsidiaries of a group. It is certainly allowed, and the amendment has does not inflict substantial changes. We merely want to clarify the policy intent. We want to clarify that as long as the merging companies are Hong Kong companies, amalgamation would be possible. As for holding companies, as for a holding company that is a Hong Kong company and another Hong Kong company, it is currently allowed, but the current provisions are not very clear. So amendment serves to clarify our policy intent. And that is amalgamation is possible as long as the merging companies are Hong Kong companies. When drafting the bill, we hope to further facilitate business and reduce compliance costs for companies. At the same time, we have to protect the interests of company members and investors, etc. We came up with the amendments to clarify policy intent by striking a balance. Thank you. Mr. Ronald Chen. Chairman, I have a more straightforward question. There are a lot of technical amendments. I'd like to know about how you promote these changes. And in past amendments of the company's ordinance, a lot of publicity and promotion efforts were done on accountants, lawyers, trade associations, chambers, etc. So would the Trade and Development Department and Business Facilitation Unit do anything in terms of promotion? We need to know what the benefits to these amendments are, and after the bill is passed, how can you ensure that your policy intent is met? So I'd like to know about the government's plans. Deputy Secretary, thank you very much. When we drafted the amendments, we maintained communication with the relevant stakeholders. I can say that most proposals came from the stakeholders themselves. The company's registry worked with the Hong Kong ICPA and different trade associations and chambers, so they were aware of our amendment exercise. After the bill is passed later, I'm sure the company's registry would carry out publicity exercises. Ms. Chung, After the bill is passed, we would continue with our publicity efforts. We would consider issuing external circulars to inform all registered companies. We would also consider writing to each registered company to tell them about the main changes involved in the bill. We would continue to hold seminars as well for professional groups, chambers, SME chambers, etc. We would also print pamphlets, and these pamphlets would be shared with newly incorporated companies. For the third round, Mr. Kenneth Leung. I'd like to talk about slide 15. You propose to allow a company with both an English and Chinese name to display either its English or Chinese name. What is the point of such change? It's rather meaningless. I find it natural to display both the English and Chinese names, so I don't quite understand the point of this change. Thank you very much. We aim to clarify certain parts of our policy. For companies, there are two requirements. One is the Articles of Association. If a company has both an English and Chinese name, both the Chinese and English names must be included in the articles. As for a company seal, either the English or Chinese name can be used, and this has been our policy intent. However, some stakeholders felt that the current provisions are not very clear. Some auditors and company secretaries are concerned that they might inadvertently breach the laws. In order to reassure our stakeholders, we propose to clarify the wording. I'm not done yet, Chairman. So in the registered office, either the English or Chinese name can be displayed. I'm not talking about letterheads, company stationery, or name cards. At the registered office of a company, would it suffice to either display the Chinese or English name? The answer is yes. I wonder whether it's a requirement of the company secretary. They said there's not enough space to display both the English and Chinese. I just find it rather surprising. Nowadays, with electronic signboards, it's easy to display both the English and Chinese names. So for company letterheads and name cards, you can either use Chinese or English. Mr. Kenneth Leung, I think this is irrelevant to our discussion today. Chairman, this is certainly relevant. We are talking about the display of English and Chinese names. This is the second point on slide 15. Chairman, according to the government, this would reduce the compliance costs of SMEs. I don't see how there are costs from SMEs. Legally speaking, both Chinese and English names should be displayed. I'm not talking about your letterheads or envelopes. I'm talking about the registered office of a company. It should display both the English and Chinese names. Perhaps Ms. Chung can offer more details. Since the new company's ordinance was enacted in 2014, we received constant questions about the display of names as well as company seals. For For example, the seal might be too small and it cannot accommodate both Chinese and English. So the current provisions have some ambiguities, and some interpret the provisions as that both Chinese and English must be displayed, and some companies encounter difficulties, and on flight tickets, in some cases the Chinese name cannot be included because sometimes these tickets are not issued in Hong Kong. Some SMEs also told us that at their place of business, for example, the menu might be in Chinese and English only, so would they have to reprint their menus because of this requirement? So we propose to clarify the requirement that only the English or Chinese name has to be displayed. And at the registered office, on the issue of the registered office, some company secretaries told us that space is sometimes inadequate, and the directory board, there might not be enough space. So this is for the sake of consistency, and we feel that the display of either Chinese or English name would be enough.
I think I've heard the explanation, but Hong Kong is an international city. At least not on all, I'm not asking for all letterheads. Say in your registered office, with the electronic display board, you display the Chinese and English name. I can't find it too difficult. Next time, you can, when you make the amendment, you can give exemptions, but at the incorporated office, the names in Chinese and English should be displayed. In fact, the company secretaries do not have any strong reaction with regard to display of names in English and Chinese. At least in one place, the public can see the Chinese and English name. I don't ask for Chinese and English name on the menu. That's unnecessary. But at the place of business, at least there is a plaque showing the English and Chinese name. That's basic. You don't know who tries to find the company and what language the person speaks. So at least you should have Chinese and English. Next, Mr. Felix Chung. Just now, the Secretary said that different stakeholders have been consulted. I want to ask whether the stakeholders are professional accountants and lawyers. Now, it's said that some chambers of commerce have been consulted. I don't know how many of these SME chambers of commerce understand the amendments because they are rather technical. As said by the director, reference is made to menu of the restaurants. These are rather piecemeal. Do you consolidate all these piecemeal comments and then you do the amendments? How broad is the consultation? Chairman, I try to answer the question. In 2016, we consulted many stakeholders with regard to the proposed amendments, including the Chambers of Commerce, the General Chambers of Commerce, the Chinese General Chamber of Commerce, Association of Banks, Institute of Directors, SME Chambers of Commerce, at least 3 Chambers of Commerce formed by SMEs and other law enforcement departments, SFC, Bar Association, Law Society, Company Secretary Association. we have consulted all the stakeholders. In 2016, we also consulted the Standing Committee on company law reform. And this Standing Committee is made up of representatives from the academia, the lawyers, and the accountants. They consider the technical aspects. As for the restaurants, how do we know the situation? After the commencement of operation since March 2014, people pay attention to the company's ordinance, and some provisions have led to concerns in the actual implementation. We have a hotline. We receive inquiries from the public. So the contact is rather broad. The hotline, in fact, receives scores of calls in a day. Chairman, do we need to have a public hearing? Well, we'll discuss that before the end of the meeting. Do members want to speak on this topic? A legal advisor? No. Well, I would say something on this. The amendment is to facilitate operation of the SMEs and help them to reduce costs is a good thing. Just now, Mr. Leung said that Hong Kong is an international city. We need to increase our transparency and enhance corporate governance. With these amendments, are there anything that is not in line with enhancing transparency and increasing corporate governance? And secondly, the size criteria is $100 million and 100 employees, $100 million of turnover or asset, and 100 employees. Is medium size rather than small. So will you change the size criteria? And with these amendments, will more companies be attracted to Hong Kong? What benefits will we get from these amendments? Thank you, Chairman, for your questions. First, Chairman, you don't need to be concerned. There are many amendments, 115 of them. As I have explained, they are rather technical. The policy intent, say, facilitate business, nothing have changed. This is to facilitate business and also protect the interests of the members of the companies and also investors. As for the size criteria, $100 million, 100 employees, the chairman said this is not a small company. We want to benefit the SMEs, small and medium-sized enterprises. As for setting of criteria, let me say that there are provisions in the existing ordinance. We are not to change the size criteria such as $100 million or 100 employees. As for the size criteria, they were set after many years of review a decade ago. At that time, the administration proposed $50 million, but the Bills Committee hoped to extend the scope so that more small and medium-sized enterprises could be benefited. Some said that there should be no upper limit. As long as all members agree, then the group can be eligible for simplified reporting. Some said propose a level at $500 million. We listened to different views. We talked to the Bills Committee then, and we came to the decision on the present size criteria. That was after much discussion and had balanced the interests of different parties. We now extend the scope to mixed groups and also groups that have non-Hong Kong subsidiaries. It's attracting more investors to Hong Kong, more companies to set up their offices in Hong Kong. Believe that the amendments will help to facilitate business, but one cannot just rely on the company's ordinance. Different government departments are working hard on attracting companies to Hong Kong. Thank you. Do members have any questions? Mr. Felix Chung, a simple question. The Deputy Secretary said that it was a consensus in those years with regard to number of employees and turnover. Concerning turnover, $100 million. In fact, many years have elapsed. Will you take into account inflation and also production cost in Hong Kong and also cost of living in Hong Kong so as to increase the level from $100 million to $200 million? For example, the Secretary, in drafting the amendments, we have listened to the views of the stakeholders with regard to size criteria. According to the stake, we have already incorporated the views of the stakeholders. They hope that different types of companies can be included. Some are mixed groups. Some companies, some groups have guaranteed subsidiaries for various purposes. A group may not just be made up of Hong Kong companies only. There are also non-Hong Kong subsidiaries. So the amendments are made with the incorporation views from different stakeholders. Any further questions? If not, then I would like to ask members whether we need to conduct a public hearing on this bill. Mr. Felix Chung, yes, I think so, Mr. Chairman. Shall we have it on the 19th of June, 9 to 12:45? Please mark it in your diary. The 19th of June, 9 to 12:45. May I thank the Secretary and her team for the detailed explanation. Thank you, Chairman. Thank you, members. Any further questions? Thank you. Thank you for coming. Meeting is now adjourned.